and myself agree on in this case. And one is that based on the evidence in this case, there was no rational basis for giving the reckless endangerment instruction that was given by the trial judge.
Well, do you also agree that the defendant requested it?
Yes.
Okay.
And the second thing is, at least as it related to the initial appeal in this case, the Commonwealth agrees that it is appropriate to review the instruction despite the fact that the defendant requested it on the theory that no case should proceed before a superior court that wasn't the subject of an indictment unless it is truly a lesser included offense, that the defendant should be enabled to review that case. And as the dissent pointed out at the appellate level in this case, the facts of this case were far from clear. The Commonwealth in this case tried the case on the theory that this was an intentional assault and battery, that Elizabeth Roderiques, either herself or by permitting her boyfriend, allowed her child to be the subject of an intentional assault and battery. Reckless endangerment does not contain any element that requires an intentional assault and battery. In fact, it's a crime that is completely different in that it punishes other types of conduct. It enlarges the group of people that can be charged with it. And by virtue of the fact that the elements are different, it's the defendant's position that it is not a lesser included offense.
Well, let me challenge. I hate to where there appears to be agreement. I hate to rent that asunder. But why would it not be reasonable for a jury in this case to have determined that while they were not persuaded beyond a reasonable doubt that the defendant had permitted the boyfriend to cause a substantial bodily injury to the child, that she wantonly or recklessly engaged in conduct that created a substantial risk of serious bodily injury, that she didn't necessarily permit him, that is, I know he's doing it and go ahead and do this to my baby, but that she had fair warning based on his prior conduct and other statements he made that meant that his caring of the baby produced this substantial risk, and that she was wanton and reckless in allowing him to be with the baby without her supervision.
Because the rule indicates that a crime is a lesser included offense only if each of its elements is also an element of the other crime, and the lesser crime contains no additional elements of its own. It is therefore clear in this particular case that there are mutually exclusive elements.
Which are?
Which are, with respect to assault and battery, substantial bodily risk, substantial bodily injury, it requires an assault and battery versus, in the situation of 13L, a risk of serious injury, which can be any type of injury, whether it's intentional or not. It distinguishes the difference between permitting versus acts or omissions.
Yeah, but all you're saying is that the risk is, to use statistical parlance, the risk is 1.0 as opposed to 99 out of 100 or 1 out of 200. So the risk materialized. That's all the assault and battery means.
The risk, the problem with 13L is it covers all risks of any type of injury to a child, not just those that are intentional. And that would make the distinction. It also encompasses a much wider class of people, as opposed to 13J, which
so
only...
it doesn't matter that in this case, what the Commonwealth says, that yes, it encompasses people who are under the age of 18, or right, and the other one is 14. But if you've got somebody who fits both categories, does that not matter? I mean, that is this child.
That's one of the elements, and that would be the age element. But the issue between whether the risk of an injury is necessarily a lesser included of an accomplished injury is the position that I don't agree with. And there are a number of lesser included offenses contained within the Commonwealth where you have a risk but no accomplished crime, and it's deemed to be not a lesser included offense.
I'm sorry. So you're saying that where you have a lesser included offense that says there's a substantial risk that something will happen, that's not a lesser included offense not a lesser included of the greater offense, which says that it's certain that it will happen?
It's not necessarily a lesser included offense. And it would have to be automatically a lesser included offense for the risk to always be a lesser included.
Well, if there's a substantial risk that something will happen, won't that always be present when there is a certainty that something will happen? I mean, a substantial risk of harm to a child, I mean, wantonly or recklessly allowing a substantial risk of bodily injury, why is that not a lesser included of wanting or recklessly permitting substantial bodily injury?
In Commonwealth versus Hendricks, which was the only reported case I could find addressing the elements of 13L, in that particular case, a family member drove a car in a high-speed manner in a police chase with a relative child in the back. There was no accident. There was no injury. The court found that 13L could encompass a relative who is not a person who has care and custody of the child, unlike 13JB, and that the risk in driving the car fast could have resulted in an accident, which would be an unintentional action on the part of the driver, the accident, as opposed to 13JB, which punishes only intentional conduct. So the risk would have to be focused on and connected to an intentional conduct. And that's why I think it's different.
So let's say you prevail here. What will the rule be in the future? Can a lawyer make requests of any instruction they wish from a judge, and then if the judge agrees with their request, then later on the lawyer say, well, gee, judge, you shouldn't have listened to me. Why listen to me? You were wrong to do that?
If the court were to adopt the invited error doctrine as it's established in the federal cases, any error, despite how it came to be, any defense attorney who asks for any instruction, if the instruction later turns to be incorrect, would be incapable of complaining about it on review. And stopping all review in every case, every claim, would cast too wide a net, because it would preclude review of every error, despite the fact of who contributed to it. And that's important in this case. But I asked for the instruction, and that's in the transcript. I simply said I think it's a lesser. But then there are several pages of dialogue between the judge and the Commonwealth, where the defendant is not participating at all, where the Commonwealth and the judge are reading the elements together, discussing whether it's a lesser. They actually take a night to think about it, and the next morning the judge indicates, I'm going to give that instruction, and the Commonwealth indicates, I agree. So certainly no rule of invited error doctrine should ever adopt a scenario on the record of this case where it's obvious that there's some negligence on the part of everyone in misreading this statute.
But at least as I read the appeals court, the majority's opinion, there was a substantial risk review done.
Interestingly enough, there was. And the majority opinion appears to suggest that there shouldn't be one done, but then they go ahead and do one. And that certainly would be a place I would like to be at the end of this day.
Don't they, I didn't read them, but Judge McHugh cites two, maybe more, appeals court cases where it seemed to me that, at least as he described them, substantial risk review was given in this kind of situation.
And notwithstanding the invited error language, it's not exactly stated in Massachusetts case law as in that term, but in Commonwealth versus Bino, that's a 2000 case, review was granted, and that was a similar situation at the district court level where the lesser was found to be not legally lesser. But the difference there is the lawyer, the defense lawyer, when he was asked if it was a lesser, knew full well it wasn't. And instead of telling the court that, he basically suggested to the court that they could give it if they chose to. And what the court found there is that lawyer, by standing by and allowing it to happen, knowing full well, and there's a different level of culpability, and I think it matters. That's not the case here. There's no record evidence to support that there was a knowledge on the part of the defense attorney that this wasn't a lesser, and a pressure or an acquiesce and really an invitation to the court to give it. If you want to, you can give the instruction, I believe is what is stated. So I do think the court, if they're looking to bring invited error into the state of Massachusetts, they're going to have to decide under what circumstances it makes sense. And I would suggest it would never make sense in a situation involving what appears to be simply neglect as opposed to an intentional act on the part.
Well, you say neglect, but there was a good reason for you to have done that, given the risks. I mean, you have a terrible, terrible event, and there had to be a concern that the jury would not be permitted to, would not wish to let her go, and it was a perfectly sensible thing to say, if the jury wanted to hold her accountable for what's a misdemeanor as opposed to a felony. Why was that not a perfectly sensible thing for you to do?
Because even the Commonwealth agrees, and the appeals court agreed, that there was no rational basis in the evidence for giving this instruction. So what tactical decision does the defendant gain from asking the court to give an instruction that isn't supported by the evidence? The entire theory of this case was that these injuries were intentionally inflicted. The defendant prompted a aggressive defense that this mother was a good mother, that all of these injuries occurred in a one-night span on December 24th, the day after this child had gone to the doctor because he had flu-like symptoms. The very next morning, this good mother brought this child right to the hospital, and the child was treated.
But it's not inconsistent. The fact that the injuries may have been intentionally inflicted by Sean Canberra, is that
Yes.
is not inconsistent with using the reckless endangerment on the part of the mother, who is actually the defendant here.
The defendant put on a defense indicating that this was an accident, that this child actually was placed on a recliner to sleep, a 7-week-old child, on a recliner that sat 1 foot from a bed that you had to step over to get out the door of this very small room. And it was our position, and that's part of the appeal, is that the Commonwealth's expert went too far on this issue, that it was actually an accident, that there was reason to believe that an adult weight-bearing body stepping over a child could have caused all of these injuries to occur.
Well, the jury certainly could have disbelieved it,
Yes.
could have believed that injuries were intentionally inflicted, that someone inflicted them, either your client or her boyfriend, the father of the child?
No.
No, her boyfriend. And that it happened in this very confined period of time, and that she, in some fashion, allowed it to happen, or put the baby in that position.
I disagree, and this is why. If they believed that, they would have convicted her of permitting.
Yeah, but that's not the standard. The standard is, could the jury have believed it?
As I stand here today, I don't know what what conclusion the jury came to convict her
No.
of this offense.
It's what the jury could have done, not what they actually did.
I think by acquitting her of every theory of liability under the 2 indictments she was charged with, including both an intentional assault and battery and permitting, it seems clear that the jury did not believe that she had any culpable mental state at all relating to the injuries being intentional.
So why not wanton and reckless then? That's
Because
the endangerment statute.
I would submit it's not a lesser included. If the theory is it's an intentionally caused injury, in Commonwealth versus Tavares, there was no rational basis to give a lesser included of wanton and reckless assault and battery.
But she's not the one with the intent to commit the assault and battery. There is a theory of this case, supported by the evidence, I think, that the male intended to cause an assault and battery on the child, and she put the child in circumstances that place the child at substantial risk of being subjected to an assault and battery by him.
The dissent, Justice Graham, did not agree that the evidence in this case was so clear.
Doesn't it have to be clear? Could the evidence have supported that verdict? That's the standard.
Yeah. And then the issue becomes, if it's reviewed on a substantial risk of a miscarriage of justice, as Justice Graham pointed out, the problem here is the entire case was tried on the theory it was an intentional assault and battery. Every part of the evidence, as heard by those jurors, was heard with the mind frame that this was an intentional action.
But on the part of whom?
On the part of the, well, on the part of which person?
Yes.
It's not clear.
No, that's right.
She was
So-
charged both as a principal
I
and as a
understand
joint
that,
venturer.
but the intentional action covers him. It doesn't necessarily cover her. And anyway,
Well, Ms. Tynan, we have to leave it there. Your time is up. Thank you.
Thank you.
May it please the Court, Tara Blackman for the Commonwealth. Joining me today is Assistant District Attorney Kristen Spooner. The first part of this issue that I want to address is the invited error doctrine. Because if this Court adopts the invited error doctrine in this case, which the Commonwealth asserts that it should, then this Court need not even reach the question of whether reckless endangerment is a lesser included offense of wantonly or recklessly permitting substantial bodily injury on a child.
when you ask the court to adopt the invited error, are you suggesting that the appeals court got it wrong? I mean, in the sense of you would say don't do substantial risk review, don't do any review? Is that what you're saying?
Well, Your Honor, the Commonwealth's first position, yes, would be that it should be non-reviewable. And that is, in fact, the position that all of the circuit courts that have reviewed invited error doctrine in terms of lesser included offense instruction, the Fourth Circuit, the Ninth Circuit, the Tenth Circuit, and the 11th Circuit, all of them have had the opportunity to review it in such circumstances and have found that it is non-reviewable.
Could I ask you this, though? Wouldn't it be the case that if you said that the argument would be made that it was ineffective assistance of counsel, and then you would get right back to substantial risk review, wouldn't you?
Well, Your Honor, if there had been a claim of ineffective assistance of counsel, but there was no such claim in this
I
case.
understand that at the moment, but that doesn't mean it wouldn't come.
Well, Your Honor, I think that in this case it wouldn't come because there was a clear strategic reason for requesting the instruction.
But my point is, the argument would be made, the court may reject it, but the court would review it under a substantial risk standard.
Well, not if the defendant requests, in those cases, as in this case, the defendant requested a lesser included offense instruction. There was no claim of ineffective assistance of counsel in those cases, and the defendant then comes back on appeal and claims it was error to give the instruction, and the court says, look, in these circumstances, it's non-reviewable. There was no claim of ineffective assistance of counsel.
Is trial counsel and appellate counsel the same person?
Yes, Your Honor.
Well,
yeah.
you're not going to get a claim of ineffective assistance of counsel on this appeal.
Your Honor, that's true, but there's also another reason why you're not going to get it, and it's because there was a clear strategic reason for requesting the instruction, and that is that
Do we have
it
an
allowed-
affidavit from counsel that makes that so clear?
No, Your Honor, we don't, but it can be inferred from the record, and the reason for doing so is because, as the appeals court stated in the majority opinion, it allowed the jury to penalize less severely the defendant for the same conduct when there was substantial evidence of the defendant's guilt on the offense for which she was charged. And so it is the Commonwealth's position that it should be non-reviewable. And in fact, all of the circuit courts, federal circuit courts, have adopted the invited error doctrine, and barring exceptional circumstances have found that it is non-reviewable. And that is also a position has been adopted by several state courts.
Do the federal courts have a substantial risk of a miscarriage of review standard?
No, Your Honor, it's a different standard, and sometimes they do review it if there is a fundamental error. But even the Commonwealth's position is, even if we give the benefit and we say, look, it is entitled to some standard of review, at the most it is entitled to is a substantial risk analysis. And even if we give that substantial risk analysis, we come out to the same outcome, which is there's no substantial risk of a miscarriage of justice
That
in
may
this
be, but
case.
I just wanted to ask you this. Are you aware, and maybe there is, but I can't think of it right now, of any area of the law in which the Massachusetts courts have said no review, none, zip?
Well, Your Honor, in Lannon versus Commonwealth and also in Commonwealth versus Vinnie, I think there was certainly that suggestion that invited error wouldn't allow in for any review. However, there hasn't been a case such as this where generally the court will give some standard review in Massachusetts. And again, the Commonwealth understands that, look, our position is certainly that it should be non-reviewable in these circumstances when a defendant actively requests, based on principles of equity and based on fairness, especially where there's a clear strategic reason behind asking for the instruction, that it should really be non-reviewable. But certainly if there is a standard review which this court looks at, substantial risk is the standard that should be used in this case. And if the court does, if that is the default standard, which it would be in this case, as the appeals court found, there was substantial evidence to support the conviction on the greater offense of which he was charged, and there was a clear strategic reason for requesting the lesser included offense of reckless endangerment.
What about the defendant's argument that because this was not a lesser included offense, the court really didn't have any jurisdiction over it? And jurisdiction questions, of course, can always be raised.
Well, Your Honor, yes, that's true. But I would ask this court to look to Commonwealth versus Bino in that situation. Although that was an appeals court case, further appellate review was denied in that case, and that was a situation where the defendant had not even expressly requested the instruction, but it was a situation where the judge had given a lesser included offense instruction, a crime that wasn't in fact a lesser included offense, and the defendant had acquiesced in that. And in the end, the court said, look, if it was a constitutional error here, if we had some kind of constitutional error, if this was another felony with which the defendant had been found guilty of and was not charged in the indictment, we'd have a real problem because that would be a constitutional error. But we don't have that here because just as in this case, it was a misdemeanor. At most, we have a statutory violation. And what does that lead us to? It again leads us to a substantial risk analysis. Now, of course, in this case, it's the Commonwealth's position that even aside from the invited error doctrine, reckless endangerment of a child is, in fact, a lesser included offense of wantonly or recklessly permitting substantial bodily injury on a child, because there is no additional element that needs to be proven for the lesser included offense that would need to be proven for the greater offense.
Could I just ask you about that? It's a conceptual problem I'm having. I understand the argument, but I'm wondering the elements-based approach of Maury and Vick and whatever seems to sort of look at not what are the circumstances of this case, but, X crime has these elements and Y crime has these. But here, in order to take your argument, we have to look at not the conduct, but sort of the status of people, that we have this child who's 3. Do you know what I mean? In other words, it isn't pure on paper. You have to actually insert the background facts of this case to get to where you are. And I'm wondering if that's consistent with an elements-based approach.
Well, Your Honor, I don't know if you actually have to insert the facts of this case, because although there are superficial dissimilarities between the two offenses, and the Commonwealth recognizes that, when you actually look at the content of the actual elements of the offenses, what you find is that there are no additional elements for the lesser offense that would need to be.
For example, I'm just this, and maybe this isn't a good one, but the endangerment one has a whole, one of the criminal areas that is implicated is sexual abuse.
Well, actually, Your Honor, yes, and that's true. There's a serious risk or substantial risk of serious injury or sexual abuse.
Right.
So it's an alternative. That still fits as a lesser included of the greater offense, because it's not saying that there has to be sexual offense. There's just an alternative.
And so it doesn't matter that it's available.
Exactly. It doesn't matter.
But then you really are, because if, for example, if you had a case where the charge related to sexual abuse of this child, let's just say, you couldn't make this argument, right?
That would be correct, Your Honor, yes.
So that's what I mean about you've got to look at the facts in order to do this.
Well, but I think often you have to look at the facts, and I think the Commonwealth has cited a case in its brief where there was a case of attempted murder by, there are other methods, by strangulation, by drowning, and in that case the court found, look, just because it's one method doesn't mean that it's not a lesser included offense. Just because there's one form form of it doesn't mean that it's not a lesser included offense. Here you have that scenario. You have a scenario where the risk of serious bodily injury, which you necessarily have to have in order to have serious bodily injury, is the lesser part of that, of the greater offense. So that fits into the scope of the greater offense. There is no additional element that you need to be proven. It needs to be proven for the lesser offense in this case that would not need to be proven
What's
for the
the
greater
age,
offense.
which you have to establish that the child is under what age?
Yes,
for the
Your Honor.
lesser included.
So for the lesser included, you have to establish that they're under 18. For the greater offense, you have to establish that they're under 14. So necessarily, any child under 18, it would necessarily be under 14.
No, the other,
so again,
other way around.
right, exactly. Yes, Your Honor, correct. Any child under 14 would necessarily be under 18. Again, same situation. No additional element. Anything you would need to prove for the anything you would need to prove for the lesser offense, you would already need to prove for the greater offense. So again, there is no basis for saying that this isn't a lesser included offense. Now, in the dissent, Graham's dissent in the appeals court decision, there was a suggestion. His reasoning on this was, look, even if you adopt the invited error doctrine, substantial risk in this case, and he jumped to the conclusion that this wasn't a lesser included offense. But there's really no analysis. And when you do a thorough analysis, you see that there is no additional element and that this really is, for all meaningful purposes, a lesser included offense of the greater crime. And now the Commonwealth has acknowledged that, okay, if you even look apart from the invited error doctrine, and even apart from the fact that this is a lesser included offense, there really wasn't, based on the evidence presented, a theory of the case upon which the court could find that the defendant was that there was a theory upon which a jury would find the defendant wasn't guilty of the greater offense than the lesser offense. And I think my sister pointed this out. However, that is okay, because what it allowed to do, and this was the clear strategy behind defense counsel asking for the instruction, was that it allowed the jury to punish to convict the defendant less severely for the same conduct. And inconsistent verdicts this court has said numerous times that inconsistent verdicts is not something for which a case should be reversed on. There was a clear strategic reason for what the defendant did. And again, the question is whether there was a substantial risk of a miscarriage of justice. This is not a case where the defendant objected. This is a case where the defendant actively requested the instruction. And I asked this court also to look to Commonwealth versus Simcock, another case pointed out in the Commonwealth's brief. And that was a situation where a lesser included offense instruction was given. And the court said, look, there was really no theory in this case, based on the facts that were presented to the jury, upon which the jury could have really found the lesser included, but not the greater offense. But that's okay, because what we come to is substantial risk, because the defendant in that case did not object to the instruction, and there was a clear strategic reason for not objecting to the instruction.
I'm still perplexed by your concession, because I know the theory of the prosecution's case was that she permitted him.
Right.
But why could the jury not be skeptical of that and say, we don't really feel certain that she permitted him, but we do agree that she created a substantial risk by knowing how he handled the baby and not taking appropriate care. Why is that not a reasonable thing for a jury to have done?
Well, because it certainly seems, and perhaps it is, but it certainly seems that permitting the lesser included offense would include allowing. It certainly seems that it's really getting at the same thing, permitting the defendant, Sean Cambra, not the defendant, to do what he did, or creating that type of risk where he was in the position, allowing him to creating that risk where he was allowed to create that risk of serious
That's what wanton and reckless conduct is all about, is allowing certain risks to exist. In this case, endangering a child.
Right.
That's what child endangerment statute gets at, doesn't it?
Right. And I would suggest that that's also what the greater offense gets at, wantonly or recklessly permitting the substantial injury of the child.
Was Sean Cambra, was he prosecuted?
I think he was prosecuted, but I don't know what happened with the outcome of that. So, but again, what we end up with at the end of it all, if any review is appropriate, which of course it's the Commonwealth's position that in this case, because of the invited error doctrine, it should not, review isn't even appropriate. But if there is any review appropriate, it's a substantial risk. And when you look at the evidence of in this case, there was substantial evidence to convict of the greater offense. There was evidence that the victim in this case had rib fractures, had a dislocated arm, would have been crying hysterically at the time of the injuries, would have been in great pain. Certainly, there was evidence from the defense expert contrary to that this could have been accident. But the question, as this court has already pointed out, is not what the jury, what if there was evidence to the contrary, but what the jury could have believed. And here there was ample evidence, substantial evidence, for the jury to believe that, in fact, the defendant was guilty of wantonly or recklessly permitting substantial bodily injury to occur on this child. And therefore, there was necessarily enough evidence for the jury to convict on the lesser included offense. And here, what the defendant got was essentially a benefit by having the jury. Yeah.
Your time is up.
Thank you, Your Honor. I rest on my brief the remainder of the argument. Thank you.